Let's talk about Miranda warnings. When and how are they supposed to be implemented? Hi, my name is Carl Birkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now, and I want to help you make law easy by just talking a little bit about your Miranda rights and when and how those warnings are actually supposed to be issued. Guys, I cannot tell you how many times I get cases or I get clients, and one of the questions I'm always asked is, well, shouldn't they have Mirandized me? Why didn't they Mirandize me? Should they have actually read me my rights? They didn't, so this should just get thrown out, right? Not really. Okay, so Miranda rights only really come into effect if you're actually being taken into custody. Not just if you're, stopped on the side of the road and the cops having a chat with you. It has to actually be like you are under arrest, getting placed in the back of the squad car with the handcuffs on, the whole nine. So if you're being detained, but you're not actually being arrested, they don't have to Mirandize you. They can still talk to you, and anything that you say will still be used against you. They don't have to trigger. They don't have to actually formally read you those rights at that time. It's only after you're actually in custody. So let's say, um, we'll use a silly example. Let's say you get pulled over, and the officer goes, you were going a little fast there. And what's the hurry? And you go, oh, well, I just killed 3 people, and their bodies are back in the back of my truck. Yeah, that statement's getting in. Like you weren't arrested, you were barely detained. Cop just asked a question, you answered it immediately, and you all the way incriminated yourself and confessed to a crime. That's a statement that can be used against you, and they don't have to warn you about your Miranda rights before that. Now, this kind of leads me into another thing with Miranda rights, which is if they don't Mirandize you, but you don't say anything that adversely affects your case, it's an error, but it's a harmless error. So let's say, they fully arrested you, they took you into custody, took you to jail and all that, and they sit down and start talking to you, and you just say, yeah, I think I want a lawyer. And they stop asking you questions at that point. Well, you haven't said anything incriminating. So even though they didn't read you the rights, you're still going to be okay. And the case is still going to move forward, though, because it's not something that's actually going to impact the proceedings. They didn't do it, but nothing was said that would have been covered by that anyway, so it's just kind of a wash. These things can get tricky, and timing is very important. If you have questions about were you in custody, were you not in custody, should they have Mirandized you, if you think that's an important part of your case, absolutely give us a call. I'm more than happy to sit down and talk with you about it and see what we can do to get this figured out. My name is Carl Birkhead. I'm an attorney with Wirth Law Office, and I want to help you make law easy. Thank you.